So I so in the earlier clip, I said that it is natural, yeah, for the buyer to reject delivery and therefore refuse to pay. Okay, so that's why this section is usually relied on when wrongful non-acceptance happens. Okay, and it doesn't matter whether the property in the goods has passed or not, but usually the property has not passed yet. Okay, so an example that I can give you is that what is meant by section 56. Okay, section 56. X, the seller, and Y, the buyer, okay, enter into a contract. Enter into a contract for the sale of 100 tons of iron, okay, at 800 ringgit per ton. Okay, and the price of 800 ringgit per ton is higher than the market price, but that is agreed by X and Y. Okay, so X according to the contract to deliver the iron to Y. However, Y wrongfully refuses to receive the iron, and therefore Y also refuses to pay. So according to section 56, what X is entitled to compensation. But what compensation would that be? Okay, so as I said, the contract was for the sale of 100 tons of iron, okay, at 800 ringgit per ton. Okay, so the contract price between X and Y is 80,000 ringgit. And the purchase price of 800 ringgit per ton is higher than market price. Okay, but that does not matter because that was agreed by the buyer and the seller. So let's say the market price is 700 per ton. Okay, so if X sells the iron to because Y, okay, the original buyer refuses to receive and refuses to pay. So if X, okay, the seller sells the iron to other buyers at market price, he will get 70,000 ringgit. Okay, so there is a differential sum of 10,000 ringgit, which also means that the seller is suffering losses at 10,000 ringgit because the contract price is 80,000 and the market price is 70,000. So here the compensation that X is entitled would be 10,000 ringgit, being the difference between the contract price and the sum for which X could have obtained and delivered it. Okay, and then the second example is that there is a contract of sale, okay, between Obama, the seller, and Trump, the buyer, for a second-hand Honda Civic bearing registration number XYZ1234, and the price was 70,000 ringgit. And no time is fixed for delivery. However, later, Trump tells Obama that he will not accept the car if the car is delivered to him. So Obama wants some compensation. So according to section 56, Obama is entitled to compensation. Of course, he will bear the burden to prove that he has suffered losses due to Trump's wrongful refusal to accept and pay for the car. So when Obama and Trump were negotiating for the sale of the car, there was another man, Biden, who was interested in the car too. Biden offered 80,000, but due to the friendship with Trump, Obama decided to sell the car to Trump at 70,000. But Trump tells Obama that he will not accept the car if it is delivered to him. So Obama now can ask for compensation of 10,000 ringgit being the excess which he could have obtained if not for Trump's wrongful refusal. Okay? Because the agreed price between Obama and Trump is 70,000 and the price offered by Biden is 80,000. Okay? And the third part is failure of buyer to pay for goods. So that is provided for by section 55 sub 1. Okay? Which provides for the remedies of the seller when the buyer fails to pay for the goods. Okay, where under a contract of sale, the property in the goods has passed to the buyer and the buyer wrongfully neglects or refuses to pay for the goods according to the terms of the contract, the seller may sue him for the price of the goods. Okay, so the operation of section 55 sub 1 depends on the fact that the property in goods has passed to the buyer or not. Okay, and the buyer wrongfully neglects or refuses to pay for the goods according to the terms of the contract. Okay. So in essence, under section 55(1), if the property has passed to the buyer and he fails to pay, the seller may sue him for the contract price. But if the property has not passed, and regardless of whether delivery has been made, as long as payment is due, but he fails to pay, then the seller can sue him for the contract price. Okay, under section 55(2). Okay, so it doesn't matter whether property has passed or delivery has been done. As long as payment is due, but no payment is made, the seller can sue the buyer. Okay. So the difference between section 55 and section 56 is that under 55, it does not matter whether there's delivery or not. Okay. Particularly under 55(1), yeah, it does not matter whether there is delivery or not. It is only concerned with whether property has passed or not. And what the seller can ask here under 55(1) is the contract price. Okay, just like the example of Obama and Trump just now, if the property or ownership, okay, of the Honda Civic has passed from Obama to Trump and Trump wrongfully refuses to pay, Obama can sue for 70,000 ringgit, the contract price, instead of the differential sum. Okay, so in essence, under 55(1), if the property has passed to the buyer and he fails to pay, the seller may sue for the contract price. Okay, but under 55(2), it provides for where property has not passed. Okay, when property has not passed, and regardless of whether delivery has been made, as long as payment is due, okay, that is when it is time for the buyer to pay according to the contract, but he fails to do so, then seller can sue him for the contract price under 55(2). So here, 55(2), it doesn't matter whether property has passed or delivery has been done. But the important element is that the payment is due, but no payment is made. Then the seller can sue the buyer for the contract price. Okay. But the only problem with 55(2) is the phrase "a day certain." Okay, there will be no problem if the parties have in their contract of sale agreed on a particular date that payment shall be made by the buyer to the seller. But if there is no such agreement, then the phrase "a day certain" seems to suggest that something must have happened to make a day or a date certain. Okay, so earlier on we have seen section 56, okay, which deals with a failure of buyer to accept goods, and then section 55, failure of buyer to pay for goods. There might be confusion as to whether sections 55 or 56 is to be used in a particular situation. Okay, so In essence, when the property has passed but the buyer fails to pay, then the seller can go under 55(1) to ask for the purchase price to be paid. But when the property has not passed and the payment has become due, okay, and the buyer fails to pay, then the seller may seek for remedy under 55(2), also for the contract price. And when the buyer refuses to accept and pay for the goods, then the seller can ask for compensation. Okay. So the wordings of section 56 is wide enough to cover both the situation where property has passed or property has not passed. So the seller in effect has an option to sue either for the price under 55(1) or for damages under 56. Okay. So 56 is for compensation or for damages, but 55(1) is for the contract price. Okay. And then apart from section 55 and 56, the Sale of Goods Act also provides the seller with additional remedies against the goods in the event of non-payment by the buyer. Okay, in other words, if the buyer fails to pay, the seller has 55 and 56 to ask for money. Now there is another remedy which the seller has over the goods, that is under section 46. Okay, because 55 and 56, as I said just now, is to ask for money. It's either for the compensation or for the contract price. But for apart from these two, under 46, the unpaid seller has goods has certain rights over the goods. So we need to know first, who is an unpaid seller. Okay, this is defined in section 45(1), which says that a seller of goods is deemed to be an unpaid seller when the whole of the price has not been paid or tendered, or when a bill of exchange or other negotiable instrument has been received as conditional payment and the condition on which it was received has not been fulfilled by reason of the dishonor of the instrument or otherwise. Okay, so this is provided for by section 45 subsection 1 paragraph A and 45 subsection 1 paragraph B. Okay, paragraph A is quite self-explanatory because it means that the buyer has not paid or offered to pay for the goods. And then paragraph B essentially refers to payment by a bill of exchange, for example, check, okay, which is subject to clearance. So if the check is later dishonored, which means that there is no sufficient amount in the buyer's account, then the seller would not be able to draw the check. Consequently, the seller is considered as unpaid because there is no sufficient amount of money in the account of the buyer to pay the seller. So the seller is considered as unpaid. So when the seller is unpaid, he has certain rights over the goods. This is stated in 46(1). Okay, section 46(1) says that he has a right of a lien on the goods for the price which while he is in possession of them. B, in case of the insolvency of the buyer, a right of stopping the goods in transit after he has parted with the possession of them. And C, a right of resale as limited by the SOGA. Okay. Okay, so let's look at the first one, right of lien. Okay, a lien is basically a right which entitles a party to hold on the possession of the goods pending payment of a debt owed. Okay, that means if you don't pay, I have the right to hold the possession of the goods until you pay. Okay, so in our case here, it refers to the right of the unpaid seller to retain the possession of the goods pending payment of contract price by the buyer. So section 47 sub 1 lists down 3 circumstances under which a seller may detain the possession of the goods until the buyer paid for the goods. Paragraph A is where the goods have been sold without any stipulation as to credit. Okay. Paragraph B, where the goods have been sold on credit, but the term of credit has expired. And paragraph C, where the buyer has become insolvent. Okay. So what paragraph A means is that the trading or the sale and purchase between the parties has been on cash basis. Okay. But there is no payment being made by the by the buyer. Okay. And then for paragraph B, when the sale is on credit and the term of credit has expired, this simply means that the buyer fails to pay when it is time for him to pay. Okay. And then paragraph C provides for a situation where the buyer becomes insolvent. Okay. Then you have to refer to section 2, which defines or which tells you when does a person become insolvent. It is when he has ceased to pay his debt in the ordinary course of business or cannot pay his debts as they become due. Okay. Whether he has committed an act of bankruptcy or not. Okay. Okay, so if the contract is an indivisible one and parts of the goods have been delivered, then the seller may exercise his right of lien on the remainder, unless such part delivery has been made under such circumstances as to show an agreement to waive the lien. So this is the position stated under section 48. When the contract is number 1, indivisible, number 2, parts of the goods have been delivered, and number 3, right of lien can be exercised on the remaining goods yet to be delivered. Okay, so in other words, if the contract is severable and one installment is delivered but not paid for it, the seller can only exercise lien over that particular batch. Okay, the seller has to deliver all other installments which have already paid for. But if the parties have agreed, either expressly or impliedly, that the seller shall not exercise his right of lien over the unpaid installment, then the seller is to waive the lien. Okay? And lien may be terminated, okay, upon occurrence of an event. So that is under section 49. Okay, section 49 sub 1 says that the unpaid seller of goods losses his lien. Okay. Paragraph A says that when he delivers the good to a carrier or other bailee for the purpose of transmission to the buyer without reserving the right of disposal of the goods. Okay. So under paragraph A, delivery to a carrier normally ends the seller's lien. Okay, because we say that the carrier is the agent of the buyer, unless it can be shown that the carrier is the seller's agent. Okay, whereas paragraph B says that the unpaid seller of goods loses his lien when the buyer or his agent lawfully obtains possession of the goods. Okay, so this is just stating the obvious. Of course, when the goods have reached the buyer or the agent, okay, lawfully, then the seller would not be able to exercise his lien anymore over the goods. Okay, so and the possession here refers to physical possession. Okay, so to end the seller's right to lien, the buyer must have taken actual control of the goods. And then paragraph C is by waiver. That means the seller waived. Okay, the seller waived his own lien. Okay, and this waiver may occur either expressly or by implication. Okay, so for example, a sale by credit, okay, where the buyer is entitled to the delivery of the goods first without having to pay first. Okay. And then the second right, okay, is the right of stoppage in transit. Okay, just now we say that a lien is normally ended when goods are delivered to a carrier for transmission to the buyer. Okay, but section 50 allows the seller to intercept, meaning to stop the goods in transit, and to resume control and his right of lien over the goods. Okay, this is stated in section 50. And the exercise of the right of stoppage will not generally rescind the contract. It only means that the seller, after getting back the goods from the carrier, has a right to retain them until the buyer pays for them. Okay? And you'll see later, the seller may even go and sell the goods which he repossessed. Okay? So, and we say that the right of stoppage is a step further than the right of lien, because in a lien, the goods are physically still with the seller. So the seller has control over the goods when anything in section 47 that I mentioned earlier happens. But in the right of stoppage in transit, the possession of the goods has been handed to the carrier. But due to some events like insolvency of the buyer, the seller may stop the carrier and regain possession of the goods. Okay, so for example, if you have ordered something, okay, from KL, and when you are in Sinto, you are in UUM, and any of the event which would attract the right of the seller to exercise stoppage in transit, he can stop, okay, even though he has sent out the goods, okay, to the carrier, and the carrier, for example, is on the way in Ipoh, okay, coming to Kedah, okay, to deliver the goods to you. He can stop the carrier, he can stop whatever courier company in on the way, okay, in Ipoh, in Tanjung Malim, in Penang, in Alor. Okay, so that is basically what is right of stoppage about. So the right of stoppage under section 50 can be exercised by the seller when the buyer becomes insolvent and the goods are still in the control of a carrier. Okay, but you have to be careful that in the case of Refinix, it has been stated that mere suspicion of the buyer's insolvency is insufficient. Okay, so if stoppage in transit is carried out and it is later found out that the buyer is not insolvent and the buyer is entitled to delivery of the goods and to receive an indemnity from the seller for any loss caused by the stoppage. Okay, mean to say, if you buy the goods, okay, from the seller or from the supplier from KL, and the seller finds that you have become a bankrupt or you have become insolvent, okay, and it could be due to some mere suspicions, okay, but and then because of this suspicion, the seller stopped the carrier in Penang, okay, but later on the seller found out that you're actually not insolvent. It's just a misunderstanding of for whatever reason. He found out that you are not insolvent, okay, but he stopped anyway. He stopped the delivery anyway. So if you suffer any losses because of this stoppage, you can claim from the seller. Okay, if it is later found that you are not insolvent. Okay, so according to section 50, if you look at the wording of section 50, the right of stoppage can be exercised when the goods are in the course of transit. Okay, in other words, when the goods are no longer in transit, the right of stoppage becomes unavailable. Okay, then you have to look at section 51. Okay, you have to look at section 51 to tell you when will goods no longer be in transit. Okay, section 51 sub 1 says that when the buyer or his agent on behalf of the buyer takes delivery of the goods from the carrier or other bailee. 51.2 says that when the buyer or his agent on behalf of the buyer obtains delivery of the goods before their arrival at the appointed destination. So in short, it has arrived at the buyers. Okay, and then in 51.3, it says after the arrival of the goods at the appointed destination, the carrier or other bailee acknowledges to the buyer or his agent that he holds goods on the buyer's behalf and continues in possession of them as bailee for the buyer on his agent. Okay, it's immaterial that a further destination for the goods may have been indicated by the buyer. And 51.6, where the carrier or other bailee wrongfully refuses to deliver the goods to the buyer or his agent. Okay. However, when the goods have arrived at the buyer, but the goods are rejected by the buyer, and the carrier or other bailee continues in possession of them, the transit is not deemed to be at an end. Okay, even if the seller has refused to receive them back. This is the position stated in 51.4. Okay, and the position of transit has been aptly summarized by the court in Bethel and Clark, which you can read, okay, from the slide. So how does a seller exercise his right of stoppage? That is stated in 52 sub 1. That's either by taking actual possession of the goods or by giving notice of his claim to the carrier or other bailee in whose possession of the goods are. So when the seller wants to take or wants to exercise his right of stoppage, he can go and take the goods back from the carrier, or he can give notice to the carrier. Okay, and when the notice is given to the carrier, it can be given to the person, okay, the employee who in whose actual possession the good is in, okay, or to the principal. If it is given to the principal, the notice must be given at such time and under such circumstances that the principal, by the exercise of reasonable diligence, may communicate it to employee or agent in time to prevent a delivery to the buyer. Okay? So, after a proper notice has been received by the carrier, he has a duty not to deliver the goods to the buyer. Instead, he has to deliver them to the seller. And if he fails to do so, he might be liable for tort of conversion. Okay, meaning to say, dealing or giving the property of someone to another person. Okay? And it is not the duty of the carrier to investigate the justification in stopping the goods. Okay, because section 52 sub 2 requires the carrier to deliver the goods according to the directions of the seller. And of course, the expenses will be borne by the seller. Okay. So in essence, when the seller exercises his right of lien over the goods or right of stoppage in transit, the seller regains possession of the goods and therefore his lien as unpaid seller. So effectively, the seller is restored to his original position before the goods were delivered to the carrier for transmission to the buyer. But this time with additional right granted under section 54(2), okay, to resell the goods and recover from the buyer damages for any loss caused by the buyer's breach of contract. Okay. Section 54 sub 1 emphasizes that lien or stoppage does not generally have the effect of rescinding the contract. Okay, so because as a general rule, a delay in payment does not give rise to an immediate right to terminate, okay, unless time of payment is of the essence of the contract. So the contract remains in force despite the stoppage by the seller. So that's why we say that the seller is bound to deliver the goods on payment of the price by the buyer or by his trustee in the case of bankruptcy. Okay, because the contract is not rescinded yet. So if the buyer is ready to pay, then the seller must be ready to deliver. Okay, and the third right is right of seller to resell. Okay, this is a very valuable right given to an unpaid seller after he has exercised his rights of lien or stoppage in transit. Okay, so after exercising the right of lien or stoppage in transit, the seller has a right to retain the goods until the buyer pays the price. So if within the reasonable time after the exercise of such a right, the buyer does not pay the price, the unpaid seller may resell them after giving notice to the buyer of his intention to resell. Okay, he can resell them if the goods are of perishable nature or where the unpaid seller who has exercised his right of lien or stoppage in transit gives notice to the buyer of his intention to resell. Okay, or the seller may recover from the original buyer damages for any loss occasioned by his breach of contract. However, if there is any profit from the resale, the original buyer shall not be entitled to any profit. Okay, this is the position if the notice of resale has been given to the original buyer. Okay, but in the event that no such notice is given, the unpaid seller shall not be entitled to recover the damages for any loss caused by the buyer's breach. And if there is any profit from the resale, the buyer is entitled to the profit. Okay, so this is under section 54(2). And then there is another situation under which the seller may resell the goods regained. That is under section 54(4). That is when the seller expressly reserve a right of resale in case the buyer should make default. Okay, so under this subsection, it's the prior agreement of parties in the contract that if the buyer defaults in payment, there is an express right and power to terminate the original contract. Okay, so that the property in the goods goes back to the seller. Okay. So when the seller resell the goods to a new buyer, he can confer a good title on that new buyer as against the original buyer. So when the new buyer obtains title under the resale, the seller may nonetheless be liable to the original buyer for breach of contract, particularly when no notice has been given. Because we said that non-payment will not give immediate right to the seller to rescind the contract. Okay, so if this happens, the seller, by selling the goods to the second buyer, may be liable to the original buyer for breach of contract, especially when no notice has been given. This is by virtue of section 54.3. Okay. So under 54.3, the seller can transfer a good title to the buyer on the fact that the property in the goods has not passed to the original buyer, or the sale by a seller in possession in the circumstances set out in section 30 sub 1. Okay. So here you have to be careful, okay, between the difference between transferring of title under section 30 and 54.3. Okay, under section 30, the new buyer is required to have bought the goods in good faith and without notice of the previous sale. But if it is a resale under section 54 sub 3, there is no such requirements. Okay, so under 54 sub 3, the buyer obtains good title, okay, regardless of whether he knows or he doesn't know that the seller has regained goods through the exercise of his right of lien or stoppage in transit. Okay, so in other words, 55.3 is wider, okay, than section 30. Okay, and another one is the defeat of right of lien or stoppage in transit, meaning to say the seller may lose the right of lien or stoppage in transit. Okay. So the general rule is that the unpaid seller's right of lien or stoppage is not affected by any sale or other disposition of the goods which the buyer may have made. So for example, if the goods are in fact sold, okay, or by the buyer, the unpaid seller may continue to exercise his right of lien or stoppage in transit. But there are a number of exceptions, okay, and this can be found in section 53 sub 1. Okay, number one is that the unpaid seller has assented, okay, to the subsale or other disposition of the goods. Okay, for this you can look at the case of Mordaunt Bros and British Oil and Cake Mouse Limited. Then number two is that where a document of title to goods has been issued or lawfully transferred to the buyer. Okay, he transfers transfer the document to another person who takes in good faith and for value by way of a sale. The unpaid seller's right of lien or stoppage in transit is defeated. Okay, so this is what we said just now. Okay, and then there are also remedies available to the buyer, okay, when the breach is committed by the seller. So the first one is damages for non-delivery of goods. Okay, that is stated by section 57, where the seller wrongfully neglects or refuses to deliver the goods to the buyer may sue the seller for damages for non-delivery. Okay, so to apply section 57, the non-delivery must have happened. Section 57 cannot be applied in the case of anticipatory breach. Okay, so there must be a breach. Okay, but not that you expect a breach would happen. Okay, so for 57 to be applied, breach must have, non-delivery must have happened. Okay, and if the buyer has already paid for the contract price, he is entitled to recover the price. Okay, in addition to any other damages that are legally obtained. Okay, when there is a breach of warranty, then the buyer may also ask for damages. Okay, then we'll look at section 59.1. Okay, 59.1 provides for the remedy of breach of terms of the contract relating to goods actually delivered and accepted by the buyer. Okay, and 59.1 covers both the situation where there is in fact a breach of warranty by the seller and where the buyer elects or is compelled to treat any breach of a condition by the seller as a breach of warranty. So under such circumstances, the buyer will have several options. Okay, number one is under section 59.1, where the buyer cannot reject the goods, but he may choose under paragraph A or paragraph B. Okay, he cannot reject the goods, but under paragraph A, he may set up against the seller the breach of warranty in diminution or extinction of the price. Or when he cannot reject the goods, but he may sue the seller for damages for breach of warranty. Okay, so 59.1 paragraph A is applicable when the seller sues for the price. Okay, the buyer is entitled to set up as a defense the breach of warranty in diminution or extinction of the price. Okay, this means that because of the breach committed by the seller, the price has thus diminished or extinct. So as a result, the buyer is not paying the price. Okay. Then the buyer can also ask for specific performance. Okay, the main remedy of the buyer in the event of non-delivery is a claim for damages, but in some circumstances, the court may order for specific performance. Okay, and this is stated by section 58. And to use this section, the goods that the parties contracted for sale and purchase must be specific or ascertained goods. Then only the court can order specific performance by the parties. Okay, for this you can look at the case of Mensa Mercantile. Okay, Mercantile, and for damages for breach of warranty, you can refer to the case of Mondel and Steele. And the last is action in tort. Okay, like I said just now, for tort of conversion. Okay, so for this, we end the topic on sale of goods. Okay, and then when you come back from the break next week, we will start with law of agency. Right? Thank you.